Chapter 20 Amendment of the Constitution. In every written constitution, a provision is always inserted providing for its amendment. This is particularly so in a federal constitution such as ours. We may examine the provisions relating to amendment found in other federal constitutions of the traditional type. United States of America, Article 5, the following four methods are specified. 1. Proposal by Congress by a two-thirds vote in each House and ratification by legislatures of three-fourths of the states. 2. Proposal by the Congress by a two-thirds vote in each House and ratification by conventions called in three-fourths of the states. 3. Proposals by two-thirds of the state legislatures and ratification by three-fourths of the state legislatures. 4. Proposal by two-thirds of the state legislatures and ratification by conventions called in three-fourths of the states. Switzerland, Article 118 to 123. 1. By a majority vote of each house of the federal legislature and ratification by a popular referendum requiring a majority of the total vote and a majority in a majority of the cantons. 2. Proposal by initiative petition signed by 50,000 electors. If this proposal is in the form of a specific amendment, it must be submitted by the federal authority as it stands. If it takes the form of a demand that the National Assembly prepare an amendment embodying a general principle set forth in the petition, the Assembly must first submit to popular vote the question whether such an amendment should be prepared, and if this is approved, then prepare an amendment and submit it to popular vote, subject in each case to the same requirement as to majorities. Provision is also made for a complete revision of the Constitution, initiated by a vote of both houses, or by one house alone, or by a petition of 50,000 electors. If demanded in any of these three ways, the proposal is submitted to popular vote. If approved, the legislature is elected afresh to draw up the new constitution, and this revised constitution is then submitted to popular vote. Australia, Section 128. The process of amendment consists of three stages. The proposed law must be passed by an absolute majority of both houses. It must be submitted to the electors not less than 2 nor more than 6 months after its passage through both houses. If it is approved by a majority of the electors in a majority of the states, and by a majority of all the electors voting in the Commonwealth, it may be presented to the Governor-General for his assent. There are two exceptions to the rules stated above. 1. The Governor-General may submit a proposed law to the electors, though it has passed only in one house, if that house has passed it twice, and the other house has twice rejected it, an interval of at least 3 months having elapsed between the occasions on which the first mentioned house has passed it. 2. The second exception is that no alteration diminishing the proportionate representation of any state in either house of the Parliament or the minimum number of representatives of a state in the House of Representatives, lower house of Parliament, are increasing, diminishing, or otherwise altering the limits of the state, or in any manner affecting the provisions of the Constitution in relation thereto, can be made without the approval of the majority of the electors voting in that state. 2. The British North America Act 1867, as originally enacted, contained no provision for its amendment by the Dominion Parliament. The British Parliament amended the Act only in 1949, empowering the Dominion Parliament to amend that Act except as regards certain specified matters. Even as late as 1951, the British Parliament had to alter the British North America Act, enabling the Dominion Parliament to enact laws in regard to old age pensions. The Dominion Parliament is not competent to deal with any of the subjects assigned by the Constitution Act exclusively to the legislatures of the provinces. The provincial legislatures are competent to amend their own constitutions, except as regards the office of Lieutenant Governor. 3. It will be seen from the American, Swiss, and Australian constitutions that any amendment of the Constitution, whatever its nature, requires ratification by a specified proportion of the units of the Federation through the unit legislatures, conventions, or referendum. Thus, in other federations, a plan of double action is provided for: action by the general or national legislature, and in addition, action by the legislatures or the electors of a majority of the units. This applies to each and every amendment of the Constitution, whatever the provision sought to be altered. Our Constitution provides for 3 different methods by which it could be amended. 1. By a simple majority in both houses of Parliament. Example, Article 4, 169, 239A. 2. Amendment by a special majority in each House of Parliament, that is, a majority of the total membership of the House concerned and a majority of not less than 2/3 of the members of the House present and voting. The first paragraph of Article 368 provides for this in relation to matters other than those dealt with in the proviso to that article. 3. Amendment by a special majority in each House of Parliament in the manner described in item 2 above, and in addition, ratification by the legislatures of at least 1/2 of the states. This applies to the matters enumerated in the proviso to Article 368. Amendments which require ratification by the states relate to election of the President, extent of the executive power of the Union and of the states, high courts for Union territories, the Union judiciary, the state high courts, legislative relations between the Union and the states, distribution of legislative powers, representation of states in Parliament, and Article 368 itself. In a federal setup, it is necessary to ensure that the units are always associated in full measure with any amendment of the Constitution. The list given in the proviso to Article 368 cannot be said to be exhaustive of the provisions in which the states have a vital interest. To give some examples, whereas the provisions relating to legislative relations between the Union and the states, Chapter 1 of Part 9, could not be amended except with the support of at least 1/2 of the states. The provisions relating to administrative relations between the 2 layers of authorities, Chapter 2 of the same part, could be altered by Parliament without the consent of the states. Again, Articles 268 to 279 contain provisions relating to the distribution of revenues between the Union and the states. It's open to the Union to modify these provisions subject to a special majority in each House of Parliament, and even consultation with the states is not necessary. Similarly, the provisions relating to the official language in Part 17 are also subject to alteration under the main paragraph of Article 368, and the states have no voice in the matter. Right from the commencement of constitution making, the role to be assigned to the states in altering it was considered by persons interested with the task of drafting the Constitution. What we are here concerned with is the extent to which the states should be associated in the amending process. Under the proviso to Article 368, ratification by only one half of the states is required, and that too only for the amendments relating to the provisions mentioned in that proviso. The number of states is now 18, and one half of that number is 9. The possibility of a constitutional amendment being effected with the support of states whose number is equal to the number of states who oppose it cannot be completely ruled out. Thus, an amendment can become law with the support of just 9 states, although the other 9 may oppose it, and the amendment may be to the detriment of the opposing states. This contingency, however remote, cannot be disregarded. One half of the number of states at any given time need not necessarily be the same thing as the majority of the states. When the number of states is an odd one, a constitutional amendment can be carried through with the support of a bare majority of 1. With the federalizing process in operation, it's always safer and desirable to associate a substantial number of states in the amending process without making it either too rigid or too flexible. In the United States of America, the ratification has to be by 3/4 of the states, and in Switzerland and Australia, any amendment of the Constitution, in addition to ratification by a majority of the units, has to be ratified by a popular referendum by a majority vote. In his memorandum dated the 30th of May 1947, the constitutional advisor made a proposal requiring ratification by not less than 2/3 of the units. An identical suggestion was made by Sir N. Gopalaswamy Iyengar and Sir Alladi Krishnaswamy Iyer. We therefore recommend that it may not be laid down that the ratification should be by 3/4 or at least 2/3 of the states. The process of territorial alteration cannot be said to be complete still. Meghalaya, a sub-state of Assam, is to become a full-fledged state. Other union territories like Tripura and Manipur are agitating for statehood. The question of Telangana also is there. The number of states is thus liable to fluctuation. Even among the existing states, there are differences in population, resources, etc. The smaller states, particularly sub-states like Meghalaya and the Union Territories, can stand no comparison with the older and well-established states, either in size or economic development or resources. With the increase in the number of states constituting the Union, it would be possible to amend the entrenched provisions, that is, the provisions specified in the proviso to Article 368, with the support of sparsely populated states, in the face of opposition by the most populous states, namely Uttar Pradesh, Maharashtra, West Bengal, Bihar, Andhra Pradesh, Tamil Nadu, Gujarat, Mysore, and Rajasthan, which have more than 3/4 of the population of the country. This practically sets at naught the whole object behind the proviso to Article 368. Hence, in addition to the requirement that ratification should be by 3/4 or at least 2/3 of the states, it may be further stipulated that the states whose legislatures ratify the amendment should represent 3/4 or at least 2/3 of the population of all states. Population for this purpose may be defined to mean the population as ascertained at the last preceding census, of which the relevant figures have been published. It will be observed that according to our proposal, the ratification will be by 3/4 or at least 2/3 of the population of all states through their legislatures, and not by a simple majority of such population. The reason for this is that a bare majority of the total population of the states will mean only the population comprised in the densely populated states such as Uttar Pradesh, West Bengal, Tamil Nadu, etc., and the amendment could be carried with the support of these populous states in the face of opposition by the less populous states. Our recommendation, if implemented, will increase the sense of participation of the states in the process relating to the alteration of the Constitution, besides ensuring stability and acting as a check against hasty amendments of the Constitution. We see no reason to restrict the process of ratification to the provisions specified in the proviso to Article 368. We have indicated earlier in this chapter that the states are vitally interested in several other provisions of the Constitution. On the analogy of the provisions in other federal constitutions and consistent with the federal concept which forms the basis of our Constitution, we recommend that any amendment of the Constitution, whatever its nature, should need ratification by 3/4 or at least 2/3 of the states. It may not be out of place to mention here that the Constitution could be amended in several respects by a simple majority in Parliament without even consulting the states by virtue of the constituent power conferred on Parliament by various other articles of the Constitution. We have already given some examples of these provisions. Our suggestion is confined to an amendment falling strictly within the scope of Article 368. Article 368 may be so amended as to require ratification by 3/4 or at least 2/3 of the states for any amendment of the Constitution, and not only for an amendment of the nature specified of the in the existing proviso to the article. It will be observed that according to the original proposal of the Union Constitution Committee set out in its principal report dated the 4th of July 1947, ratification by the units was necessary for every amendment of the Constitution. Our recommendation on this point will, if implemented, bring the provision into accord with the initial suggestion of the Union Constitution Committee. The necessity for associating the states in each and every amendment of the Constitution will be apparent if we examine the amendments already effected to the Constitution under that article. So far, 23 acts have been passed under Article 368, altering the Constitution. Of these, only 11, the second, 1952, third, 1954, sixth, 1956, seventh, 1956, eighth, 1959, 13th, 1962, 14th, 1962, 15th, 1963, 16th, 1963, 22nd, 1969, and 23rd, 1969 amendments have been ratified by the states. The interest that the states have in the provisions of the other 12 amendments which have been placed on the statute book under Article 368 without ratification by the states will be apparent if we examine those provisions. First, 1951, fourth, 1955, and 17th, 1964 amendments. They have substantially modified, among others, the provisions relating to the fundamental rights of the citizens dealing with discrimination, freedom of speech and expression, and property. Articles 15, 19, and 31. In the light of the pronouncement of the Supreme Court in Golaknath case, the importance of the fundamental rights would be quite obvious, and the participation of the states in any amendment of the fundamental rights would reflect the federal character of the Constitution. 5th, 1955, and 18th, 1966 amendments. These two amendments affect the territorial integrity of the states. The Fifth Amendment substituted a new proviso for the existing proviso to Article 3 of the Constitution. In our chapter relating to the territory of the state, we had occasion to refer to Article 3. As pointed out there, the proviso, as it stood before its amendment in 1955, required the central government to ascertain the views of the states concerned before introducing the bill in Parliament. It has now been altered so as to provide that all that the central government need do is to refer the bill to the states, specify a time for the expression of the views by the states, and on such expiry proceed with the bill, whether or not the states have expressed their views, and irrespective of what those views are. This underlines the need for the active participation of the states in any amendment of the provisions relating to the alteration of the boundaries, names, etc. of the states. Although the 18th Amendment is a formal one applicable to Union territories, we feel that any amendment of a provision in the Constitution relating to the territory or area of states should require ratification by them. 9th Amendment 1960. This relates to the transfer of certain territories to Pakistan. This is a glaring instance of territories included within certain states being transferred to a foreign country, and an amendment of this nature should, in our opinion, be undertaken only with the consent of the states affected. 10th, 1961 and 12th, 1962 amendments. These relate to the constitution of Dadra and Nagar Haveli and Goa, Daman and Diu as union territories. Even here, we consider that the participation of the states in the amending procedure will strengthen the bonds of unity. 11th Amendment 1961. This relates to the election of the President and the Vice President. Considering the fact that elected members of the state assemblies also are members of the Electoral College, which elects the President, and the fact that the Vice President is the chairman of the Council of States, which is composed of representatives indirectly elected by the states, any amendment relating to the relevant provisions should be effected with the cooperation of the states. 19th Amendment 1966. This has amended Article 324(1), excluding from the purview of the Election Commission the appointment of election tribunals for the decision of doubts and disputes arising out of or in connection with elections to Parliament and the state legislatures. In dealing with the machinery for conduct of elections, we had already adverted to this matter. The states, as autonomous units, are as much interested in ensuring fair and free elections as the Union. Any amendment relating to elections should, therefore, be undertaken with the consent of the states. 12th Amendment 1966. Although this amendment is a formal one, validating certain past appointments of district judges, it has to be pointed out that the provisions relating to the subordinate judiciary, that is, posts of district judges and other inferior judicial posts, are the sole concern of the states. Any amendment relating to these matters should be undertaken only with the consent of the states. 21st Amendment 1967. This is a case which indicates the ease with which the provisions of the Constitution relating to language could be changed by Parliament. No doubt, this amendment has included Sindhi as one of the regional languages in the 8th schedule, but the same method could be adopted to delete a language now specified in that schedule, as in the case of the territory of the state, in the case of the provisions relating to language also. No amendment should be undertaken except with the consent of the state. Confining ourselves to the 2 points which we have dealt with so far, namely, 1. Increasing to 3/4 or at least 2/3 the proportion of the states required for ratification of a constitutional amendment, with the condition that they should represent 3/4 or at least 2/3 of the population of all states, and 2. Subjecting to such ratification any amendment of the Constitution, and not only an amendment of the provisions specified in the proviso to Article 368. The acceptance of a proposal regarding those 2 points involves the omission of the opening portion of the proviso to the article and the insertion in the main paragraph itself of the article of the concluding portion of the proviso. Article 368 will accordingly run somewhat on the following lines. Quote, procedure for amendment of the Constitution. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose in either House of Parliament, and when the bill, after being passed in each House of Parliament by a majority of the total membership of that House, and by a majority of not less than 2/3 of the members of that House present and voting, is ratified by resolutions to that effect passed by legislatures not less than 3/4 or 2/3 of the states representing not less than 3/4 or 2/3 of the population of all states. It shall be presented to the President for his assent, and upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. Explanation. In this article, the expression population means the population as ascertained at the last preceding census, of which the relevant figures have been published.